Welcome to another edition of Question and Answer with a Criminal Defense Attorney. I'm Mark Solomon, a defense attorney in Denver, Colorado, and today's question is about GPS monitoring. But before we get to that, don't forget to click like if you're enjoying this video, and if you're enjoying all these videos, don't forget to click the subscribe button with a little bell next to it to be notified of future videos. So, pretrial services, and specifically GPS monitoring. What is it? And the answer is there are two basic reasons for the court to order GPS monitoring. And that is, number one, protecting somebody. They want to make sure that the defendant is not going near the alleged victim. Most of the time I see this, it's in serious domestic violence cases, and they are worried about the alleged victim and their safety, and therefore the court and pretrial services will give dead zones or exclusion zones, places that the defendant simply cannot go. And if they go into one of those exclusion zones, they're gonna have a motion to revoke bond because they're not complying with the condition of bond. The other reason, the second reason the court can order that, is because the person is a flight risk and they don't think they're a reliable risk to allow them to leave jail pretrial. So they put a GPS monitoring on them so that at any point the pretrial services officer knows where they are. So those are the two reasons. Number one, protecting somebody, and number two, making sure that the court knows where this person is. How are they allowed to do that? And the answer to that is it's in the statute. They are literally relying on this statute regarding bond, and they will look at this one condition here in this list of conditions that they can apply. And in this particular case, it allows for electronic GPS of the person. The next question I get all the time is, when can I get this GPS off? And the answer is after a reliable period of compliance. So in other words, if you're given the GPS and you've been on it for a month or two or three, and there have been no allegations that you've violated the terms of your go or no-go zones, or that you haven't let the stupid thing run out of battery all the time, because that's another thing that they say, if it runs out of battery, if you get low battery alarms, that's considered a problem. So if you've been compliant for a while, then we can usually get those things removed, unless it's an extremely serious case and there are some issues regarding the safety of the alleged victim. They will probably leave it on until the trial, or past that if we've negotiated something in that respect. So that is the question and answer for today. If you would like your own question in a future video, you can put it in the comments below, email it to me, or put it on Twitter, tagging me, of course. And as always, you have a right to remain silent. If a police officer asks you anything about where you've been, what you've done, what you know, or anything, you have a right to say, I don't want to answer your questions, I don't want to talk to you. Or if they persist, I want a lawyer.